up, my YouTube family? What's up, my Facebook group family? How are we doing? Tonight is our study session number 7, and we're going to talk about arbitration. Okay, we're going to use arbitration to delete negative accounts. A lot of people don't know about arbitration, but it's something that's becoming more popular. A lot of us with these collections accounts, these debt collectors coming after us, especially for sums of money, like I'm going to say about $100 and some dollars, maybe 500 and some dollars, and they don't know that when we say don't pay collections, that's exactly what we mean. Don't pay collections, because you have an option that you didn't know about that a lot of lawyers won't tell you, and you can save a lot of money just by doing this yourself. And you will come across some lawyers that are truthful, and they'll say, well, you'll save more money if you do arbitration. So we'll get into arbitration, and I'm going to show you how to delete your negative accounts with arbitration. I will be hosting a masterclass on arbitration, showing you how to go exactly through the application process. What type of paperwork do you need? How much money you'll have to pay? I will show you the whole 9 yards. Okay. I do want to explain to you all that I'm not a lawyer. I am not a financial advisor. So if you need anything dealing with lawyer's advice or financial advisor advice, please consult your consumer lawyer and a financial advisor. Anything I say on here is on my videos or on all of my platforms that where you watch me. Anything on here is for educational purposes. Okay? It's for educational purposes. All right. So let's get into arbitration. All right. Let's talk about deleting paid charge-offs and paid collections. So I'm specifically saying paid charge-off and paid collections because a lot of us get duped into paying these because they'll put things on our credit report, and that's when they do that, they're doing that to coerce you to make a payment. Okay, that's the whole purpose of them putting anything on your credit report, is to drop your score, knowing that you need credit. Credit is everything, y'all. You may not think it's something to you, but credit is everything, because I feel like you're doing a disservice to yourself when you're paying for everything in cash, because you can use credit to make money. Okay. And watch my videos. I go into detail with a lot of that stuff. But I want to specifically talk about deleting paid charge-offs and paid collections on this study session. You can also use this method to dispute with a creditor. So not just a debt collector, you can also use this method to dispute with the creditor, especially for high interest rates, insurance premiums that were included inside of your finance charges that you didn't know about, or your agreements for that matter, and et cetera, et cetera. So we need to know the difference between a CRA and a creditor and a debt collector. CRA, anytime you hear me say CRA, I'm talking about the consumer reporting agencies, right? That's at Experian, TransUnion, Equifax. Also talking about the big four: LexisNexis, Innovis, LCI, ARS, CoreLogic, those type of companies. Those are the CRAs, the consumer reporting agencies. A creditor is the original owner of the debt. Okay. When anytime you hear me say creditor, I'm talking about the company that you actually signed an agreement with, and a company that you actually opened that account with. That's the original creditor. The debt collector is pretty much the third party where the debt was actually transferred to or sold to. So you really didn't go into a contract or an agreement with them. They have to show the burden of proof is not on you. The burden of proof is on them. But they will still try to pursue these lawsuits, these debt collection lawsuits, and get you to pay. And the worst thing that you could ever do as a consumer is not answer the complaint, the lawsuit complaint. Another thing is not show up for the actual date of court date. Because if you don't show up for the court date, they can actually tell the judge what they want and lay it all out in the list. Since the consumer didn't show up, didn't bother to show up, judge, grant me everything that I'm asking for. So you don't want that to happen, because they can get a judgment against you, where they can garnish your wages, they can levy your bank accounts, anything you have in your name or with your social security number, they can potentially take money from you. Okay. So now I've broken down the different types of persons in the law. Person mean for a corporation, individual, company, business. You get what I'm talking about. All right. So damages. The name of the game is violations. The only way that you can have a viable claim against a company is that you need to find how they damaged you. They can damage you emotionally or economically. Okay. So how did they damage you? One of the three easiest ways you can figure this out is by checking your credit report. Download your credit report from annualcreditreport.com. You get them free. You get a free credit report every 7 days. The only thing about annualcreditreport.com is that you can't see your credit score. Okay. But you just want to use it so you can see the actual accounts and look and compare through each one to see what type of reporting any inaccuracies on your credit report. For example, like payment history. And I go into detail on some of my videos where you can, what things you can look for in payment history. But we're talking about arbitration today. Okay. Another way you can look to see how a company damaged you is customer service issues. Like you trying to get an issue resolved, but nothing got resolved. For example, like turning in equipment, like with DirecTV. You turned in the equipment. They stated that you didn't turn it in. So they're billing you and they're charging you and they're reporting this information to your credit report. That's an inaccuracy because indeed you paid it, but they're reporting, making it look like that you did pay it. Another way that you can find out that they're damaging you is that issues with the actual contract or agreement itself. For example, you can check your state laws and see what their maximum yield on a company charging you interest rate. So you can take a look to see if this company is actually charging you high interest rate. The reason why I say you want to have a violation is because not paying a debt is not suffice enough. Okay. And I'm going to go into more detail later on in this video, in a study session, where not paying a debt can actually help you when it comes to arbitration. But on the good foot, I need you to figure out where this company is violating you. Try to find any type of violation. The name of the game is violation. Soon as you can open up a dispute, soon as you can dispute that debt. Okay. So the name of the game is violations. Okay. All right. So we're talking about disputing with the CRA, creditor, or debt collector. When you do this, you need to ask for specifics. So if you're asking them for information, you need to ask for any type of disclosure. You need to ask for specifics. They do not have to have an arbitration clause for you to take this route. So let me make this clear. If a company or a person has an arbitration clause, good. We're going to use that arbitration clause and flip that and put that okie doke back. We're going to do the okie doke back on them. Okay. So in other words, we're going to put the okie doke back on them. All right. Another thing is, if they don't have an arbitration clause, you still can arbitrate. You can still arbitrate with these companies. Okay. All right. So you're going to ask for the application. You're going to ask for the credit card application. You're going to either ask for the offer, because a lot of times you apply for these credit card companies and you didn't have a paper application. You may have seen an offer online and you did the offer online. You want to ask them for that specific offer that you applied for. You want to ask for monthly statements, and you want to ask them to correct any reporting issues. This is where you're going to let them know. You're not going to let your right hand know what your left hand know what your right hand doing, but you want to ask them for this because we want to see if they're going to correct anything. Okay. We're going to say the next response or the next notice and let them know how exactly they're violating you or damaging you. Okay. When you ask about them to correct any reporting issues. All right. Now, did you get what you wanted? So when you disputed with this company, did you get what you wanted? If you did not get what you wanted, you know for a fact that this company is violating you. You can either arbitrate and or CFPB complaint, Consumer Finance Protection Bureau complaint. You can do arbitration or you can do both. Because what you do when you do both, you're like killing two birds with one stone. So when you ask them to arbitrate and you filed that CFPB complaint, you're letting CFPB know that this company violated you and you're going to do arbitration. That's letting CFPB know that you're going through the proper channels to get this dispute handled, taken care of. So with the debt collector, you need to check to see if the original creditor had an arbitration clause. So if you have a third-party debt, what that means is if you have a third-party debt collector that's trying to take you to court, or even if they haven't taken you to court yet, if you know that this debt collector is trying to make you pay an amount and you know you didn't go into contract or agreement with this company, you need to check with your original creditor. That's why you need to ask them for the information that I had on the previous slide, so that to see if they have inside of their arbitration clause that if if this account is sold or transferred, that the next party falls under the same rules of arbitration as the original creditor. So you need to check to see if the third party is bound by that same agreement. Okay, so always checking that if you don't have the arbitration clause, call the company or put it in writing and ask and request for that arbitration clause. A lot of credit card companies, CFPB has a website where you can go to and you can type in CFPB arbitration clauses. When you Google it and you click on that link, and it'll take you to a page on the CFPB where you click on it and find your credit card company, and you can actually see your arbitration agreement online. So you don't even have to contact the company, especially if it's a credit card account. All right. I need you to drop those ones in the comments. Drop those hearts in the comments if whatever I'm speaking about resonate with you. If you're enjoying everything that I'm saying in this study session today, it has been great. Arbitration I hadn't even gotten into the meat and potatoes of this arbitration. It's just dumbfounding to me how a lot of people don't know about this. And you know how many people, if they were informed consumers like my viewers are, it's like it opened up a whole new world. It's like you don't even know you got this power until you met K.E.Y. Okay? And I mean conceded K.E.Y. Okay, let's keep going. I'm back and goofy. Let me get off being goofy. All right, so we want to compare arbitration. So anytime a company's trying to sue you, especially if it's in debt, I'm going to say a debt less than $4,000. I'm just a ballpark figure because the companies pay a lot of money to do arbitration. You as a consumer would pay probably no more than $200. Now, if the debt is $100 and you know that you owe it and you want to go ahead and pay it and pay for delete, I don't normally pursue pay for delete. But if you want to pay it and you got $200 and the account is less than $100, go and pay. My advice: go ahead, pay it, get out the way. You don't have to worry about doing any of this. But if you just one of those consumers and you know you can get out this debt, you just want to pay it to see how everything turns out, by all means, do what you want to do. You your own boss. You know, you just think about the consequences and think about your actions when you do it, okay? So when you compare arbitration, you want to check your state's arbitration process. All right, there's 3 different processes to it. There's a pre-credit reporting dispute. You can do arbitration before they even report it to your account if you know that they're actually reporting this, and you can do this before you even dispute with the company saying that they're reporting inaccuracies. So if it's on your credit report and you know it's on your credit report, you can actually do arbitration, and you know they're reporting inaccuracy, don't dispute. Go ahead and proceed to arbitration. During your dispute or filing the CFPB complaint, and put them on notice there. So you can compare arbitration during a legal procedure. If you're going to court as of right now for this company that's trying to get you to pay this debt, you can do arbitration during this time. You can do all of this during this time, okay? And after the lawsuit has already been filed. So after it's already been filed, you can pursue arbitration. Like I was saying in the last step, if anytime and that's depending on whatever jurisdiction that this actual lawsuit is covered under or is pursuing under, some judges won't grant it. Okay, I've seen people where the judges won't grant it. So, and a lot of times they do, because that actual company did have an arbitration clause, and they make you binded by it. So you can actually compare arbitration during the actual lawsuit, in court, I might say, if that helps you out. All right, so what I did was I found a copy of an arbitration clause with a company. What you want to do is, once you get a copy of the arbitration clause, you want to mark up your arbitration clause, your arbitration agreement, to see what each provision says. What company to arbitrate. It also lets you know what company to arbitrate with. Normally it's AAA or JAMS. Know the procedures, the lender's information, and how to serve them. Because a lot of times they'll tell you, if you're going to compare arbitration, we have an email address that you can send it to. Everything is in writing. So when you email them, that's a form of written communication. So make sure you keep all of this. Keep copies of everything. So you notice, look at my sheet. I went through it. I highlighted the exact things that I needed. So when I actually when I did an arbitration, when I had to go to court, those where you see the highlighted parts, I actually included those inside of my motion to compel arbitration. So I knew exactly what it was, and I knew what words to use so that the judge can approve it, and approved it. And I'm going through the arbitration process now. All right. So the procedure, make sure you know what the lender's information and how to serve them. Fees and costs, sometimes the lender pays. So make sure you read the section carefully where it says about fees and costs, because you don't even have to come out of pocket. Some companies will pay your fees and costs, especially your lawyer's fees, if you have to retain a lawyer, if you have to pay for a lawyer. Some lawyers won't even charge you when you're doing arbitration unless you get paid. Okay. So once you get your arbitration agreement, I need you to mark it up. I need you to study it carefully. Okay, the part what I took out, I took some snippets out so you can see exactly what these arbitration. This is actually an arbitration, which is a forced arbitration. Okay, this one states that it provides that certain disputes between you and lender, if not settled by mediation, will be resolved by mandatory binding arbitration. That is forced arbitration, and I'm gonna tell you why it's forced. Okay, you thus give up your right to go to court or to bring or participate in a class action over those disputes. Your rights will be determined by a neutral arbitrator, not a judge or a jury. That in arbitration, I do want to disclose that when you do arbitration, you go through the process. Those judges are actually retired lawyers and judges. Okay, so they're mediators. You are entitled to a fair hearing, but arbitration procedures are more limited than rules in court. So rules in court are they're more conceptual to the point where they have like a it's like what they call it, it's more structured in a court setting. It's structured in arbitration, but they're a little bit more lenient when it comes to court rules in arbitration. So an arbitrator decides and are enforceable in court, but are subject to very limited review by court. So they would rather have everything settled during arbitration than you to take that actual arbitration that you did and pursue it and ended up with pursuing it in court. So they want you to, this one states, consult a lawyer if you do not understand this agreement. So now the reason why I said that it's a forced arbitration, because I just told you in the beginning of this arbitration clause that it says that if not settled by mediation, will be resolved by mandatory binding arbitration. You thus give up your right to go to court. And in statement 1, section 1, it states that agreement to arbitrate. Subject to sections 2 and 3, you and lender agree that as part of and as a consideration for your loan, any claim, dispute, or controversy, whether in contract, tort, under statute, otherwise, arising from or relating to any of the following shall be resolved by binding arbitration. Let me keep going. I want to drop down to the arbitrator's decision cannot be appealed and is subject to only limited judicial review. So they're telling you, if you go through arbitration, you cannot, the arbitrator decision is final. So that right there is forced arbitration. Some arbitration can be taken back to court, but this actual clause is telling you that no, if whatever goes on with arbitration, it sticks with arbitration. That's the final word. So that's forced arbitration to me. All right. It also states that it's telling you what in section 4 is telling you what to use. They're telling you to use AAA. Now, in some arbitration clauses, contracts, they'll tell you that you have the option. But in this one, they're telling me that AAA is the only one to use. A lot of companies use AAA because AAA leans more to the companies than they do the actual consumer, because if it wasn't for the companies doing arbitration, the arbitrators wouldn't make money. They make money from the actual companies. Think about it. They don't actually, in arbitration, they don't really make money off consumers. They know you pretty much owe the debt. So they will actually, if you don't have a valid claim, that's why I say make sure you got damages. Make sure they're violating you. Because if you just owe a debt and you just not paying it, they're gonna rule in favor of the creditor or of the creditor or debt collector. So make sure you have a valid reason, because they can choose the arbitrator that they want. All right. So next up, and make sure y'all write notes. Please write notes. I do have the section where fees and costs. In this one it states you will not have to pay more to initiate mediation and arbitration than it would cost to file a lawsuit in my jurisdiction. So if you depend on small claims court, justice court, county court, circuit court, whichever court you go to, depending on the amount of the debt. Like in the jurisdiction that I had to do this one in, they the charges was like $166. That's how much it costs to file a motion to compel arbitration. If I was to choose, since I chose arbitration, I only had to pay $166. Okay. And it also states that lender will pay your reasonable attorney fees and costs as determined by the arbitrator. So they're offering to pay your lawyer's fees if this ends up in your favor. If you had to pay the lawyer, whatever fees, costs, filing, whatever it is you had to pay, they will pay that. Okay. So just read it. And a lot of times with arbitration, check your when I was talking about you answering to the complaint, the debt complaint, answer it, check your insurance, because sometimes your insurance, like your mortgage insurance, or you may have insurance with your job that will pay for your lawyer so you can go through this process of arbitration. So check that. All right, these are the two that's popular. That's JAMS, Local Solutions, Global Reach. They do arbitration. I think JAMS is a little bit higher because AAA is $200, but I think JAMS is a little bit higher. But do your own research. Always fact check behind me. Never take my word for face value. AAA is the American Arbitration Association. Check those, because with this, they will be paying a lot of money. So just say, for instance, you have a debt that's $1,000. With AAA, I know for a fact the consumer will only pay $200 if you were to pursue arbitration yourself. But if the company was sending you to court, as in my arbitration agreement, I only had to pay what I would pay to file a motion in my or motion to compel in my jurisdiction. But if you're pursuing this, if you're initiating this arbitration, AAA charges the consumer $200. And I do have a video that shows you this actual how much everything costs. So please go back to my YouTube videos and watch those. Watch that video. But the company, if you owe $1,000 and the company has to pay an initial fee of $300, then they got to turn around and pay $500 per hour, maybe $250 per hour. Think about that. It may take 2 days to do this arbitration. Then they got to pay $1,400 court fee. Then they got to pay the actual arbitration process. They will be out of more than $1,000 to even pursue this. That's why they would rather send you to court first, because in the arbitration, they'll tell you that you have to go to arbitration. But then in another clause, they'll say that despite Section 1, we can, if you're in default, we can initiate a court complaint, or we can take you to court for this debt because you're in default. But you're not knowing and understanding that you can compel and pursue arbitration. So if you owe a debt of $1,000, they're 9 times out of 10, they're going to backtrack. They're not even going to pursue you for that debt. They're going to leave it alone. Okay. Once they decide that they're not going to pursue you, they're probably going to do a charge off, or they're probably going to do a collections. So when they do a charge off, you need to make sure that you get something in writing stating that they're doing a charge off, or they're not going to pursue this debt. Because if you don't have anything in writing, make sure they delete it from your credit report. Also, put that in your notice too. When you send, after everything is over, you need to have them sign something stating or giving you something in writing stating they're not going to pursue the debt anymore, or however way they're going to pursue it. If they do charge off, you need to send me a copy of the 1099-C, and you need to delete this. I need a written statement from you saying that you're going to delete it from my credit report. Make sure you get that settlement. They call that accord and satisfaction notice. Make sure they give that to you in writing. But AAA would be your best out because it's the cheapest. But AAA is more in favor of the creditor than it is, and debt collector than it is the consumer. So make sure you got your ducks in a row. All right, so I want you to be aware of forced arbitration. In forced arbitration, a company requires a consumer or employee to submit any dispute that may arise to binding arbitration as a condition of employment or buying a product or service. So if you're in that loan company and you read the arbitration clause and you tell them that no, you don't want to do arbitration, and you end up catching this while you're in there, you can tell them, I want to opt out of arbitration, and they deny you credit. That's against the law. They cannot deny you credit for that. Okay. They're still supposed to go through the credit process and allowing you to apply for the credit. Now, if you don't catch that clause when you're inside of in your visit to the loan company while you're applying, and you see it later on down the road in your paperwork, some companies give you 60 days to opt out. If it's over 60 days, I'll still send a notice letting them know that I opt out of arbitration. I'll still send that notice. Because they use that so you won't, get involved in a class action suit, because they're doing this to a lot of consumers. That's why they're forcing you into arbitration. So the employee or consumer is required to waive their right to sue, to participate in a class action lawsuit, or to appeal. But if you choose not to and you don't see the arbitration clause, that's why I'm here doing this study session. You can do a motion to compel arbitration, or you can just literally use their information and put them on notice and let them know that you want to go through arbitration. But it does cost a fee, no more than $200 from what I paid. Okay. But check the website. Make sure you check the info on how to do that. And make sure you be on the lookout for my arbitration masterclass now, because I do want y'all to have the hands-on approach to everything so that you can be able to do this. And when you learn how to do this, you can teach your family how to do this. Imagine how many of your family members have gone through court or not shown up and got their check garnished and couldn't pay their light bill, or gone through this and had to have their house foreclosed because this company that actually garnished their check. And in states they can't garnish no more than 25%. But that's a loss. That's heartbreaking. That's emotional stress. That's that emotional damage I'm talking about. Okay. All right. So in all of this, I want you to take action. If you're not comfortable taking action by yourself, then I can guide you with the full breakdown of the steps needed to pursue arbitration. You do not need a lawyer to do this. Okay. Some lawyers will tell you. So I would like for you to go to my Consumer Scholars University website and enroll in my arbitration course to get started today. All right. You can contact me on my social media. If you ask me on my YouTube page, you can comment on my videos. I'm always reading my comments. I'm always responding to my viewers. So out of this whole process, there are benefits to it. So the benefits to arbitration is that it's cheaper than hiring a lawyer. You get more of the monetary remedy. So if you go through the arbitration process, and you see that they're violating you on other laws too, make sure you include that when you go to arbitration. Make sure you have all these exhibits and all of this stuff laid out. Because if you're seeking remedy for them breaking laws and they're required to pay a certain monetary amount, you can get paid during arbitration. You could get paid, and the arbitrator can approve this to where they have to pay you. If it gets to the point, I have heard, if it gets to the point where an arbitrator rules in your favor and they have to pay you, and they don't pay you, then you can pursue them in regular court to get your monetary remedy, because there are companies that don't pay after arbitration. Another benefit is the cost. It costs just as much to file in your county or jurisdiction. Okay. And the lender bears the costly burden, especially with debts less than $4,000. The lender, they're going to pay out way more money than the actual creditor, than you will, rather. And you will get those negative accounts deleted, because you're going to request for them to delete those accounts. And you could get paid out, as I was saying, depending on how bad the damage and the dispute process was. So if you had to go through extreme emotional stress, emotional damage, and they were reporting as you were going through this process, and they were still reporting inaccuracy to your credit report, include that in your arbitration. You can get a remedy for that. That's a violation of the law. Okay. All right. So you can contact me on YouTube, TikTok, Instagram, Facebook, and also I have 2 Facebook pages for Boss Moves. And I do have my website, my Consumer Scholars website. I want to thank you all for watching me, participating, commenting, liking, subscribing. I just love you all. I'm almost at that 1,000 mark. So please, please, please get everybody that you know, chime them in, subscribe. I need to have 1,000 subscribers party on YouTube. That's what I need to have. Okay. Love y'all. Thank you all for watching.